Welcome to our Hare Court presentation on post-employment notice pay. I am joined today by colleagues Tom Poole and Emily Moore. We're going to be talking you through several elements of PENP, as I'm going to refer to it. Tom is very helpfully going to provide an overview and how it is calculated, which is far from straightforward, but hopefully it will be by the time we have finished this session. Emily Moore is then going to address the changes to PENP, which are going to be coming into force on the 6th of April this year, as well as talking through any ramifications of COVID, which have been impacting on lots of different areas of employment law. Finally, I am going to be looking at the practical hints and tips for getting the tax treatment of these termination payments right. Just a little bit about our speakers before we start and addressing them in the order in which they're going to be presenting to you. So firstly, we have Tom Poole. Tom Poole has a broad employment practice. He covers all aspects of employment law. He has particular expertise in conducting tribunal and high court claims, including injunctive action and relief. His work often overlaps with commercial work, and that means he acts for and against directors in claims of either breach of fiduciary duty or post-termination restrictive covenants. Tom is on the Attorney General's A panel of civil counsel, and most importantly, from March following a successful application, he is going to be a silk. Welcome, Tom. We then have Emily Moore, who does also a mix of employment, commercial and insolvency work, a very important mix at this time when all of those areas are very much intersecting. In her employment practice, Emily is instructed by both claimants and respondents across a broad spectrum of disputes. And her recent experience includes achieving the dismissal of a claim for unlawful deduction of wages brought against a healthcare staffing agency. Finally, I will introduce myself. My name is Sara Ibrahim. I head up the employment team at Hare Court. Similarly to Tom Poole, I have a mix of employment and commercial work, including those cases which cross with those of statutory director duties. My practice means I appear in the Employment Tribunal, the EAT and the High Court, and in 2019 I was reappointed to the panel of counsel for the Commission of Equality and Human Rights. Now that I have introduced us, let us get down to the important business of PENP, and to introduce us and kick everything off, we have Tom Poole. Tom Poole.
Afternoon, everyone. Let me share my screen so you can hopefully see what I can see. Now, as Sarah said, I'm going to spend the next 20 minutes or so explaining what we mean by post-employment notice pay and how it's calculated. So let's start with a rather obvious first question. What is post-employment notice pay? So where an employee is not working their full notice period, post-employment notice pay, commonly referred to, as Sarah says, as PENP, is the amount of income the employee would have received during any period of unworked notice. In other words, PENP is the basic pay equivalent for any unworked notice period and is calculated using a specified formula that I'll discuss a bit later on. PENP is essentially a different type of pay in lieu of notice, or pylon, and it's designed to ensure that income tax and NICs are paid on all payments in lieu of notice. Essentially, PENP enhances HMRC's visibility over and ability to charge to UK tax parts of termination payments relating to notice. And as we'll see, the primary goal of the 2018 statutory amendments that put PENP on a statutory footing was to ensure that the tax treatment of this particular aspect of a termination payment no longer depended on whether there is a contractual pylon expressed in the contract. So let's look at the statutory framework. The starting point is Chapter 3 of the Income Tax, Earnings and Pensions Act 2003, more commonly referred to as ITEPA. And as set out on the slide, Chapter 3 applies to payments and other benefits which are received directly or indirectly in consideration or in consequence of, or otherwise in connection with, the termination of a person's employment. Now, in April 2018, a number of new provisions were added to ITEPA dealing with the concept of PENP. The provisions that have applied since 6th of April 2018 require employers to split a relevant termination award between amounts treated as earnings from amounts benefiting from the £30,000 tax exemption. So put more simply, employers must treat a slice of a relevant termination award, which reflects basic pay for any part of a notice period not served, as earnings, and subject that slice to tax and NICs, both employer and employee. So the first question is, what is a relevant termination award? Now, a relevant termination award, or RTA, is defined as a payment or other benefit falling within section 401(1)(a) of ITEPA. And as we've already seen, that is a payment or benefit received directly or indirectly in consideration of, in consequence of, or otherwise in connection with the termination of a person's employment. Now, as the definition operates by applying section 401(1)(a) and section 401(2) provides that subsection 1 is subject to 401(3), payments or other benefits chargeable to tax apart from chapter 3, so for example, payments for restrictive covenants and contractual pylons, cannot be relevant termination awards under the statutory scheme. However, as we'll come on to discuss in a moment, it is still possible to have a relevant termination award in addition to a contractual pylon payment, and in these circumstances, a PENP calculation would still need to be undertaken. The statutorily excluded payments are statutory redundancy pay and approved contractual pay to the extent that it does not exceed statutory redundancy pay. And accordingly, these automatically benefit from the £30,000 tax exemption. So it follows that non-statutory redundancy pay is a relevant termination award and, in contrast with statutory redundancy pay, will no longer automatically fall within the £30,000 exemption. Now, perhaps unsurprisingly, the position was slightly confused by HMRC guidance, which confirmed that PENP calculations should not be applied to non-statutory redundancy payments. However, HMRC subsequently amended its guidance to more accurately reflect the legislation. If the non-statutory payment is inclusive of the statutory entitlement, so in other words, it exceeds the statutory entitlement, it is likely that only the element exceeding the statutory entitlement is a relevant termination award, although helpfully neither the legislation nor HMRC expressly says that is so. Payments falling within exceptions, reliefs and reductions in sections 405 to 414A of ITEPA, for example, employer contributions to registered pension schemes, are also relevant termination awards. However, despite being treated as relevant termination awards, HMRC has confirmed that the exceptions, reliefs and reductions apply to all payments and benefits falling within section 401 ITEPA. I think the thing to really have in mind here is that if there is no relevant termination award, so for example, the payment package to an employee on termination of their employment consists only of contractual pylon and statutory redundancy pay, PENP provisions simply do not apply. So the next question really is what is basic pay? And this is fairly straightforward. It is income disregarding overtime, bonuses, commissions, gratuities, allowances, termination awards, benefits in kind, amounts treated as earnings, and amounts that count as employment income. However, something to bear in mind is that basic pay in this context includes amounts that would have been received absent a salary sacrifice arrangement. Now, salary sacrifice arrangements in this context means any arrangement whereby the employee gives up part of their cash pay in return for something else. So, as set out on the slide, common salary sacrifice arrangements, childcare vouchers, company cars, health insurance, work-related training, car parking near the workplace, health screening checks, mobile phones, gym membership, accommodation, school fees. So having established what is a relevant termination award and what constitutes basic pay for the purposes of PENP, we now need to know what must be taxed as earnings. The tax treatment of the sum depends on the size of PENP relative to the overall relevant termination award. And employees must, firstly, tax the entire relevant termination award if PENP is equal to or more the relevant termination award, or tax-only PENP if it is less than the relevant termination award, but is not nil. If PENP's a negative amount, then that is treated as being nil. So, for example, if PENP is 0 or minus a number, then no additional tax will be due. So let's next consider the circumstances in which PENP calculations must be applied. We'll do this by running quickly through the different circumstances that I've listed on the slide. So first, whenever there is no express pylon clause, and I should add no implied discretionary or automatic pylon clause. Second, where an employee is compensated for unfair dismissal and the employee has not served out his or her full notice. Third, where an employee resigns without notice and settlement is agreed afterwards. And just bear in mind, it doesn't matter which party terminates the employment. In these circumstances, the unserved period of notice for the PENP calculation, D in the formula we'll come on to look at in a moment, will run from the last day of employment and end on the date on which contractual notice or statutory notice, if higher, would have expired had the employer served notice. Fourth, where an employee is dismissed without proper notice and offered a settlement agreement some weeks later. But just note here that a temporal gap between termination and agreeing settlement terms does not displace the application of the PENP calculation. Fifth, where an employee gives notice, but it is less than the employer's notice. In those circumstances, if the employee serves out their notice period, there may still be periods of unserved notice, and so the PENP calculation will need to be performed. This scenario really underlines the importance of bearing in mind that the calculation is always based on the employer's notice requirement. Sixth, where an employer gives notice, but the employee then gives counter notice, thereby shortening the notice period. And again, bear in mind here, even though the employee's right to give counter notice, as set out under section 1363 of the Employment Rights Act 1996, may in practice cut short the duration of notice, this should not affect the PENP calculation, which should still be based on the notice required to be given by the employer. And then finally, where there is a pylon payment and a relevant termination award. Now, as set out on the slide, this appears to be on the basis of the definition of minimum notice in section 402E4 ITEPA. And the definition is set out there on the slide. Minimum notice required to be given by the employer to terminate the employee's employment by notice in accordance with the law and contractual terms. So if the employer terminates without giving notice, there will inevitably be a post-employment notice period. This means that there could be an amount of PENP, hence why HMRC requires the PENP calculation to be made when a relevant termination payment award is paid, even though a contractual pylon is also paid and taxed in full. Now, in many cases, the PENP formula will produce a nil or possibly a negative amount. However, that will not always be the case because the amount that an employer pays as a contractual pylon might not correspond to the figure produced by the statutory PENP calculation. Accordingly, it's not safe to assume that paying a contractual pylon will inevitably result in a nil PENP figure, and therefore, if the employer is making a relevant termination award, it must run the PENP calculation. So now for the part of the webinar I'm sure everyone has been waiting for, cold towels at the ready, calculating PENP. Now there are two formulae for calculating PENP, the simplified formula and the standard or general formula. We'll deal with the simplified formula first, which applies where employees' pay is exactly a calendar month, notice period is a whole number of calendar months, and employment is terminated with immediate effect, or whose unworked period of notice is a whole number of months. Now the formula is BP multiplied by D minus T. BP is basic pay, and basic pay here means gross monthly salary for the last pay period ending before the day notice is given. Pay period is not defined in the legislation, so should be given its ordinary meaning. Now, HMRC's view is that a pay period reflects the period that the payment represents. So accordingly, if an employee is paid on, say, the 15th day of every month, and that payment represents payment for the period first of the month to last of the month, the pay period is a calendar month. You should also remember that an employee's gross monthly salary, as we said earlier, includes any salary sacrifice arrangements. So once you've worked out the basic pay figure, this is then multiplied by D, which is the number of months in the post-employment notice period that must be given by the employer. broadly the unworked notice period. Once you've carried out that calculation, you then have to subtract T, which is the amounts other than holiday pay and termination bonuses that are paid on termination and have already had income tax and NIC applied. Commonly, T covers contractual pylons. So we're going to have a look at two worked examples. In example one, we've got employee A, who's paid 6,000 monthly basic pay, has a 2-month notice period with no contractual pylon. A works 1 month of the 2-month notice period. A's employer makes a relevant termination award of £10,000. So we're applying the simplified formula. Gross monthly salary of 6,000 is multiplied by 1, because 1 month of unworked notice period, and then minus nil, because nothing is paid other than holiday pay and termination bonuses. Therefore, PENP is £6,000. As the 6,000 PENP figure is less than the relevant termination award overall, only the PENP is to be treated as earnings and is therefore taxable under section 403 ITEPA. However, if part of the termination award is a statutory redundancy payment, the relevant termination award is reduced accordingly. So in our example, if we change it, and if the termination award comprises, say, a statutory redundancy payment of 5,000 and an ex gratia payment of 5,000, the relevant termination award will be 5,000. PENP will therefore be greater than the relevant termination award, and the entire RTA of 5,000 would be treated as earnings. So let's look at another example. In example 2, we've got employee B earning £10,000 a month after entering into a salary sacrifice arrangement, sacrificing £1,500 each month. B has a 3-month notice period. B's employer exercises a contractual right to dismiss without notice and pays contractual pylon equal to 3 months' actual salary. Additionally, his employer makes a £10,000 ex gratia payment. So again, applying the simplified formula, gross monthly salary is 11,500 because basic pay in the PENP calculation reflects sacrificed earnings. So we have the 10,000 plus 1,500 salary sacrifice. That figure is multiplied by 3 for the 3 unworked months. The sum of that is then minus 3 months of pylon, which is 30,000, and that gives you a PENP figure of 4,500. Now here, the relevant termination award is 10,000 and PENP is 4,500. Therefore, the 4,500 of the relevant termination award is taxable as earnings. The contractual pylon is subject to tax in full. So now let's look at the standard formula. Now, the standard formula, or being honest, a slightly more complicated formula, applies where the employee is not paid monthly or the employee's notice period or unworked period of notice is not expressed in months. The formula here, slightly more complicated, BP multiplied by D, all divided by P minus T. Now BP, basic pay again, basic pay for the last pay period to end before the day notice is given. So here the employee could be paid monthly, this would be gross monthly salary, or if weekly, then gross weekly salary, including any salary sacrifice. That basic pay figure is then multiplied by D, number of days again in the post-employment notice period. As with the simplified formula, this is a reference to the employer's notice. You then divide the resulting figure by P, which is the number of calendar days in the pay period. So if the employee is paid monthly, this will be 28, 30 or 31. If paid weekly, then it'll be 7. Now, just to note, the employer may use 30.42 as the value for P in certain circumstances, most commonly where the employee is paid by monthly instalments, equal monthly instalments, and their post-employment notice period is not a whole number of months. So allocating P, the value of 30.42, will obtain statutory footing when changes to PENP enter into force later this year, as Emily will explain in a moment. You then subtract from the figure you've calculated T, the amount paid on termination, other than holiday and termination bonuses, but taxable as earnings. So again, let's just work through an example. Employee C is paid £2,000 fortnightly, basic pay, and has an 8-week notice period with no contractual pylon. C serves half of the 8-week notice period. C's employer then makes a relevant termination award of £5,000. Applying the standard formula, you've got a gross salary of 2,000, multiplied that by 28, that being the number of days in the post-employment notice period, i.e. half the 8-week notice period. 56,000 is then divided by 14 as the number of days in the pay period, and the resulting 4,000 is then divided by nil, because nothing is paid other than holiday pay and termination bonuses. So you get a PENP figure of 4,000. As before, the 4,000 PENP is less than the relevant termination award overall, so only PENP is to be treated as earnings and taxable under section 403 ITEPA. So I'm afraid that's been a bit of a whistle-stop tour of quite a tricky subject, but those are the essential features of PENP and how it's calculated. So just finally, by way of a recap, PENP is the basic pay equivalent for any unworked notice period calculated using a specified formula. Where an individual is not employed for the full notice period, any relevant termination award will be taxed as general earnings and therefore subject to income tax and employers and employees NICs, insofar as it is equal or less than PENP. So in our examples, if PENP is 3,000, say, but there's ex gratia is only 2,000, you would only pay income tax and NICs on the 2,000. You would not be expected to pay income tax for the whole 3,000 award out of the 2,000 ex gratia. And finally, there is no need to calculate PENP where the employee works the full notice period or where the employee only receives pylon, i.e. there's no ex gratia payment, as there would be in those circumstances no relevant termination award. Well, thank you for listening. I'm now going to hand you over to Emily, who's going to address the changes to PENP from the 6th of April this year and how COVID might.
In particular, furlough pay will potentially affect the calculation of PENP. So starting with the changes then, there are three main documents that I would recommend taking a look at. None of them are very long, and the links are here in this slide. And I'm sure the slides can be circulated after this talk. So the first is the government policy paper. This was published in July last year. It essentially has a general description of the new measure, the background to it, and the proposed revisions. Secondly, we have the draft legislation itself, which is a new clause in the Finance Bill 2020 to 2021. It's only 1.5 pages long, so shouldn't take too long to review. And thirdly, there's an explanatory note to the draft legislation, which essentially walks through each of the subsections and explains what it does. So who is the new legislation going to apply to? Very simply, it's going to apply to individuals who both have their employment terminated on or before the 6th of April and also receive a termination payment on or after the 6th of April. Now, there are two key changes, and it's important to note at the outset that these changes are only intended to fix certain unintended outcomes of the existing rules, rather than to completely overhaul any particular aspect of the existing rules. So do not panic. It's not the case that everything Tom's just gone through is going to change. So the first change in a nutshell is there's going to be a new calculation for PENP. As Tom highlighted, there's essentially a practice at the moment where the number 30.42 can be used in the standard formula. That's essentially going to be put on a statutory footing. And the second change is essentially bringing PENP within the charge to UK tax for individuals who are non-resident in the year of the termination of their UK employment. So I've just set out there on the next slide the policy objective, which highlights essentially the rationale behind these changes. So I don't propose to read it all out now. It's fairly self-explanatory, and it's essentially removing unfair outcomes, bringing fairness and clarity. And then, as I said, the second change is aligning the tax treatment of PENP for UK and non-UK resident employees so that there can be consistency across the board. So just looking at those changes in slightly more detail, the first key change takes the form of an amendment to section 402D of ITEPA. And it essentially brings in a new calculation for employees who have a pay period defined in months, but a contractual notice period defined in weeks or days, or where the employment notice period is not a whole number of months. And this will ensure that all employees' PENP is calculated consistently on the termination of their employment. So really the rationale is that the current PENP rules sometimes operate counterintuitively in certain circumstances where employees are paid monthly but have notice periods measured in days or weeks, or where they work some but not all of their notice periods. So in certain circumstances, under the current rules, employees end up having non-zero PENP despite receiving a full pile-on for their full unworked notice periods. So since October 2019, there's been published HMRC guidance, which has allowed for employers to use the average number of days in a month, as Tom said, 30.42, which is just 365 divided by 12, to stand as P in the standard formula, P being the number of days in an employee's last pay period before the trigger date, rather than using the actual number of days in the pay period, where the employee's salary is paid by 12 equal monthly instalments. And so that alternative methodology is in the employee's favour. So this change just removes that unintended inconsistent outcome, and it puts that approach, as I said, on a statutory footing. So there's going to be a new subsection 6A, and as I said, 30.42 can be used as P, and it ensures that PENP does not vary according to the number of days in the monthly pay period preceding the trigger date, where the remuneration for that period would not have so varied. So really not much of a change there, just really a consistency. And then the second key change takes the form of an amendment to section 27 of ITEPA. And as I said, that's the ensuring that non-resident individuals are charged to UK tax and NICs on PENP to the extent that their period of notice would have been worked in the UK. Now, it's important to note that this change only affects individuals who physically performed the duties of their employment in the UK. And the rationale of this is that currently PENP of non-UK resident employees from UK employment is not subject to UK tax as earnings. So this change aligns the position, and it will obviously be particularly relevant to employers with international workforces who move between working in the UK and working abroad. So those are the changes, and now I'm going to say a few words on the issue of furlough and COVID-19 and what essentially happens to PENP when an employee's basic pay for the last pay period is at a reduced rate because they have been furloughed. Now, this is a bit of a grey area. Unhelpfully, there's currently no HMRC guidance specifically addressing this point. So all we can really do at present is do our best to interpret the legislation and see how it might be said to apply to furlough. So the most obvious question that arises is, and Tom's taken us through what a salary sacrifice situation is. The most obvious question is furlough akin to a salary sacrifice situation? Now, section 402D7B of ITEPA includes within the definition of basic pay, as Tom said, any amount which the employee has given up the right to receive, but which would have been within basic pay had the employee not done so. So on its face, this definition of basic pay is certainly capable of being applied to employees who have consented to giving up part of their salary during furlough. However, I'd say there's also a fairly strong counter-argument that being furloughed or flexi-furloughed, of course, is not akin to a salary sacrifice situation for the obvious reason that there's no clear benefit to the employee in return for the sacrifice. Obviously, this will have to be assessed on a case-by-case basis. So it could be unfair to tax on the basis of the higher rate of pay rather than on the actual amount received by the employee. it's also arguable that if an employee is ready and willing to work their pre-furlough contractual hours during their notice period, they should be paid at the contractual rate for the whole notice period, including, if they're flexi-furloughed, non-working furlough days. Really, it's up to the individual employers, obviously, to make an assessment of risk versus benefit in the specific circumstances of the termination at hand. For example, in a redundancy situation, some employers may choose to pay notice at a lower rate because they're weighing the risk of litigation as being less than the immediate cost savings to the business, especially in the current economic climate. So obviously it's going to have to be, as I say, assessed on a case-by-case basis. So really, absent any guidance, and it doesn't look like we're going to get any anytime soon, although I could be wrong, the most sensible approach, if in doubt, would be to obtain prior clearance from HMRC to try to avoid any errors being made. And that concludes my part of the presentation. I'm going to stop sharing my screen and pass over to Sara.
Thank you very much, Emily. Well, the first point to make is congratulations for making it this far through on our PENP presentation. We are now in the final part. So if everything has gone according to plan, you should be seeing my slides. Now, I will be dealing with what I'm calling practical hints and tips. What does that mean? Why is it important to get this right? PENP is a very dry topic, so why do we have to invest all this time and energy in making sure we are correct with it? Well, the starting point is what happens if you get it wrong. And the main point here, which is on the slide, is it can lead to a tax liability. Now, whilst it's commonly assumed that tax liability is most likely to fall on the employer, it can also fall on the employee as well, though HMRC usually pursue employers because they tend to have more in terms of funds. So HMRC can recover both unpaid taxes and NICs. Now, there are penalties for inaccurate returns. So, for example, for PAYE, up to 100% of the tax liability can be levied for inaccurate returns. There is a scale that HMRC have set where they talk about the culpability of the employer. And there are several factors that they look at. Was any failure to make payment, was it deliberate? Was it concealed? Was it careless? And was there voluntary disclosure, or was any failure actually discovered by HMRC? So as you can probably imagine, if it is prompted but careless, then you're looking at the much lower range of penalties, usually below 30%, whereas if you've got deliberate concealments, you're looking closer to 100%. Now, HMRC's main mechanism in this case is normally Regulation 80. So that's the mechanism under the Income Tax PAYE Regulations 2003 to recover unpaid taxes from the employer, and it is wide enough to encompass what HMRC will be considered disguised remuneration arrangements. Employees can also be pursued, as I've mentioned. So, for example, HMRC, once they've issued this Regulation 80 determination, where any part of that tax is not paid within 30 days, HMRC can use Regulation 81, and that redirects, or can redirect at least part of that liability to the employee. I've also pointed out there on the slide that HMRC can exercise its general discretion under section 684, subsection 7A of ITEPA to disapply the PAYE regulations where they consider it unnecessary or not appropriate to pursue the employer. So this brings me on to drafting tips when you're thinking about settlement agreements, because I anticipate the vast majority of cases you'll be looking at settlement agreements will be in place. Now, most settlement agreements have a tax indemnity clause, and that normally shifts the tax risk to the ex or still current employee. Even where this is missing, you do have the possibility of a common law cause of action, and I've put the case there. But I think it goes without saying it is clearly preferable that you're not having to rely on that. So what is it advisable to do when you're addressing PENP in settlement? Now, if you specifically identify the sum which is being treated as PENP and record any narrative about the party's understanding, that is going to be incredibly useful if there is an inquiry or a dispute with HMRC. So if it is set out in the settlement agreement, that makes things far easier. Now, where a taxpayer seeks to allocate part of a single lump sum payment to separate elements, that is likely to encounter difficulties. By that I mean, if there's been a single lump sum and it hasn't been agreed what relates to what components, everything through loss of earnings to say injury to feelings, then HMRC is likely to cite the case, and it is on the slides there, of EV Booth Holdings. And they cite that as authority for the proposition that where the parties to a transaction have, by negotiation, attributed a payment to a component element of a transaction, the parties cannot then seek to reallocate the payment for tax purposes. Similarly, if the wording of the settlement agreement is silent. Now, a particularly interesting example, again on the slide, is the executors of Ian John Clark. Now, this was a very significant payment in excess of £15 million, so obviously attracted the interest of HMRC. The matter went to the first tier tribunal. They rejected the taxpayer's argument that the termination payment was made partially on account of his ill health, that ill health being sufficiently serious to amount to a disability, because the settlement agreement had expressly stated that it was in relation to buying out the taxpayer's pension rights. So whilst other components of the termination payment were expressly mentioned in that settlement agreement, including compensation for loss of employment, there was no express mechanism for apportioning the payment. And the available evidence in front of the first tier tribunal pointed to the entire payment being made to buy out the pension rights. The recitals made no reference to ill health, and whilst the settlement agreement recorded the taxpayer's intention to argue he had retired on ill health grounds, and this is key, the first tier tribunal found it recorded subjective intention. Now, subjective intention is not going to be enough. In words that are slightly chilling to any lawyer, in the judgment around paragraph 170, the tribunal said a very large amount of money was at stake, and it would have been professionally negligent to have done anything other than to ensure that all causes of action or dispute were excluded. That is the commercial reality. I would recommend, it is a long judgment, reading around paragraphs 138 to 177, and that talks specifically about subjective intention of the parties and how that is irrelevant for tax purposes. It must be recorded in the agreement. In a nutshell, it is far, far better if everything is expressly agreed beforehand, rather than having discussions or disputes with HMRC as to what you meant afterwards. So this takes me on to the matter of ex gratia payments, a very commonly favoured term in employment law because it describes payment without admission of liability. And if you are going to settle matters, then that is often a key component that nudges particularly employer clients into agreeing. So what is HMRC's approach to these payments? Again, you'll see that a case is referred on the slide, and this is Resolute Management Services. In that case, the employer received £150,000 ex gratia payment. The tribunal there held it was truly ex gratia, as there was no contractual entitlement to that ex gratia payment, and it was not earned. It was actually argued that this was a personal gift, a very generous personal gift, and that because of that it did not attract tax. This failed, and it was eventually taxed under Section 401 of ITEPA. So be aware that HMRC are frequently going to argue that ex gratia payments can be earnings. And if you look at Section 62, subsection 2b of ITEPA, it does in fact envision that gifts and other gratuities may be earnings. So that is something very much to watch out for. But what about tax treatment when it comes to settlements expressed as sums payable on a global basis? Well, it can be ill-advised to say something is a global settlement, especially if it conceals that some of those monies ought to be taxable as PENP. And I would refer you to the excellent summary that Tom Poole has provided. So what happens if you have said something's a global settlement and it ought to be taxed, or part of it ought to be taxed as PENP? Well, this could amount to fraud. And for example, be characterised as something such as a conspiracy to cheat the public revenue. It could open you up to offences under the Proceeds of Crime Act. And if that wasn't enough, it could potentially constitute a breach of SRA principles. And you would then have to consider whether the matter should be reported to your firm's money laundering report officer. So something, again, to consider in these matters. Moving on to more practical advice. Here we have a link to HMRC's Employment Income Manual. It is actually a quite easy to follow document for an HMRC document, and it sets out these very helpful 4 questions. Starting firstly, is the payment or benefit earnings from employment? You then have point 2, which is related to restrictive covenants, because you may wish to make a payment in respect of those. Thirdly, is the payment in connection with retirement or death? And sorry, that should say or death. And 4, finally, and this brings me back to the point I've made earlier, a lot of these payments can be caught by Section 401 of ITEPA. And that means that payments or benefits made in connection with the termination of employment. And so it is well worth looking at that income manual just to check where some of those payments may fall according to HMRC. Now, another key point to take into account. Have you made the payment before or after the termination date? Well, if payments are made before the termination date, you're likely to fall within Section 62 of ITEPA. That means that irrespective of what you may have called the payment, whether it's compensation, remuneration, it is likely to be fully taxable unless, and I've put that here on the side, unless it arises from discrimination. Payments made after termination will fall under sections 401 to 416 of ITEPA and therefore qualify for full or partial tax exemption. Now, I've put this case, and it's a very well-trodden case of Gays and Society Generale, and that is about making sure you are clear and unequivocal in your communication of termination. And that can be something that can be forgotten as a bit of a footnote, but when it comes to dealing with PENP and when it comes to HMRC's treatment of the payment, it really can be very crucial. So make sure that you are clear as to when your termination date is and whether you are paying before or after. A final point to make on this is Section 401 of ITEPA applies to payments made in relation to offices or employment. And I mention that because you will often have people who are non-exec directors and they could fall within these provisions. Finally, this is my last slide, and this is about the £30,000 tax exemption, which has been around for a fair period of time. So the £30,000 tax exemption for non-PENP payments. Well, a lot of you will be aware that the first £30,000 of payment that falls within Section 401 of ITEPA are not to be treated as PENP there. So this is a key point really in the second point. Multiple payments made in respect of the same job or different jobs with the same employer, associated employers, need to be aggregated for the purpose of the £30,000 limit. And that is under reference Section 4041 of ITEPA. Damages for breach of contract, statutory redundancy pay, or severance compensation falling within Section 401 must also be aggregated when determining the limit, even if it's paid over multiple tax years. And I think that's key there. Finally, and this is to talk about the changes that came in since 6th of April 2020, termination payments falling within Section 403 of ITEPA, but exceeding £30,000 are subject to Class 1A national insurance contributions. So that is something that is worth taking into account. Now that brings you to the end of my slideshow. Now I do still have all of my colleagues with me, both Tom Poole and Emily Moore, who are there on screen. Thank you very much. We do have some small period of time if you do have questions. However, we are aware that this is a very technical area and that you have been listening to us speak for some 50 minutes about a very dry topic. So if in fact you would prefer to drop us an email afterwards and ask any questions, you would be more than welcome to do that. Otherwise, thank you very much for your time. I hope this has been an informative one. Thank you very much.